Topic 2 on the jurisdiction of courts. So following from the last topic, after you have decided on the pre-action considerations, you decide to commence action in Hong Kong. Let's look at the jurisdiction. What does this mean? It means the scope of powers of the court. Does this court have the power to determine this dispute? If a court does not have jurisdiction, based on some statute in Hong Kong, then the parties cannot confer jurisdiction by consent or waiver or estoppel. Okay, so the statute takes precedence. The flip side is parties cannot exclude jurisdiction by agreement. So parties cannot between themselves in a contract says the Hong Kong court shall not have jurisdiction. Okay, so that would be null and void. But then in practice, the courts usually will give effect or respect the parties' choices by declining to exercise jurisdiction. So yes, you have agreed to not come to Hong Kong, then the court may decide to kick this case away to some foreign jurisdiction. Original jurisdiction means the jurisdiction to hear a case from the beginning. So the jurisdiction to hear the trial of a case. So what happens in trial is witnesses and evidence will be called. Okay, there will be live witnesses, and the court makes a determination based on the evidence and the law who wins. Okay, so that's the original jurisdiction. Whereas appellate jurisdiction, what we mean is the power to hear an appeal. And typically on appeals, if you know, there is no witnesses. It's just arguments on law. So courts with jurisdiction to hear trials in Hong Kong, starting from the smallest is the Small Claims Tribunal, and then District Court, and then Court of First Instance. And there are also other specialist tribunals. Those who can hear appeals will be DC, CFI, CA, and the CFA. So in this topic, we're mainly concerned with the first type of original jurisdiction. First, for the CFI, concept you need to know is when we refer to the word High Court, we actually mean both the CFI and the CA. So it is inaccurate or imprecise to directly say High Court. Okay, we actually mean the CFI. The monetary jurisdiction of the CFI is unlimited. So it doesn't matter how much the claim is, the CFI has jurisdiction. There are also certain matters that must be dealt with by the CFI. So admiralty, meaning shipping cases, any administrative law applications or cases, enforcement of judgments of a foreign jurisdiction, any applications under the arbitration ordinance or those under the bankruptcy or the company's ordinance. What the CFI cannot hear is matters that are within the jurisdiction of certain specialist tribunals, okay, which have exclusive jurisdiction. So we're talking about small claims and labor. District Court, actions founded in contract, quasi-contract, and tort, and the claim does not exceed 3 million. So for a claim below 3 million and less than a DC has jurisdiction. If your claim is more than 3 million, then your only choice is the CFI. If the claim is, let's say, a little bit higher than 3 million, let's say $3,003,000, then it might not make sense to commence the action in the CFI, where the scale of costs are higher, and maybe the court is more busy. Therefore, justice might be slower. So even if one has a claim who is slightly higher or just higher than 3 million, one can still commence proceedings in the DC if one is willing to give up the excess amount. If the action concerns land, I want to recover land, then the annual rent or the rateable value of the land cannot exceed $320,000.
If the matter is under the equity jurisdiction of the DC, if no land involved, the value of the property must not exceed 3 million. If land is involved, then the limit is 7 million.
If I have, let's say, a claim for 9 million, I cannot split up my claims into 3, 3, and 3 and start 3 different actions in the DC, okay, just to go under the DC jurisdiction. So there's no splitting of cause of action into smaller ones. And just like the CFI, the certain matters within the jurisdiction of the small claims and the labor cannot go to the DC. Small claims tribunal, you can see the keyword here is exclusive jurisdiction over monetary claims, where the amount is not more than $75,000. So if the amount is 75 or less, then one must only start the action in the small claims tribunal and not the DC or the CFI. Notice though, so not everything can be decided in the SCT. So look up the small claims tribunal ordinance. Same as the DC, one cannot split up causes of action in the smaller ones. And again, same for DC, one can give up an excess claim in order to make one come within the jurisdiction of the SCT. One very important point is lawyers are not allowed. So unless it is your own case, you are litigating in person, generally lawyers cannot go to the SCT. So of course there might be some very rich clients who are willing to pay for lawyers who just accompany him or her to court and to advise him sitting beside the person. Okay. Now of course that's out of proportion. Okay. So in your practice, most of the time, we don't really care about small claims tribunal because lawyers can't go there. So just be aware that if the claim is too small, then you probably have to turn the client away. Labor tribunal, just like SCT, you can see the word exclusive jurisdiction. So you must start this in a labor tribunal if the claim is for breach of contract of employment or any failure to comply with the employment ordinance or the minimum wage. Okay, so it doesn't matter how large the claim is, it must start in the labor tribunal. Although, if the court considers that there is some very complicated issue of law, or maybe the claim is very large, then the labor tribunal might decline jurisdiction and transfer it elsewhere. But the point here is, it is not your choice. So you must always start every employment matter in the LT. No jurisdiction over claims founded in tort. So there might be employment related claims. For example, your boss assaulted you, or false imprisonment, or maybe the employee has committed breach of confidence and, let's say, stole some valuable property from the employer. Those claims are outside the jurisdiction of the labor tribunal. Land tribunal, now there's no exclusive jurisdiction, so one can choose whether to go to land tribunal or DC for matters relating to land. So the first three are quite specialized. The fourth one are the ones that us practitioners will are most likely to come across. So if an action is for possession of land or for ejectment of someone, so these would be landlord and tenant cases. So a tenant does not pay rent, one can seek for possession, or order for payment of rent, or mean profits. So those one can start in the land tribunal instead of the DC. It has the same jurisdiction as the CFI to grant remedies. If an action was commenced in the wrong court, then there could be a transfer of proceedings. So let's start with, let's say, the plaintiff's claim in the district court. It's outside the jurisdiction of the DC, but within jurisdiction of the CFI. So let's say it could be more than 3 million. So DC shall order transfer to the CFI. But the DC can also strike out the claim if it is satisfied that the plaintiff knew or ought to have known that DC had no jurisdiction. Now we're just talking about the counterclaim. So plaintiff's claim is within 3 million, but the defendant starts a counterclaim that is more than 3 million. So only the counterclaim, it's outside DC jurisdiction, but within CFI jurisdiction. Then the DC has a choice. DC may transfer the entire proceeding to the CFI, so both the claim and the counterclaim. DC can choose to only transfer the counterclaim to the CFI. And third option is to keep both matters in the DC, but to report to the CFI. So the CFI then may in turn decide to make a transfer. If both plaintiff's claim and these counterclaim are within jurisdiction of the DC. Now this, on the face of it, does not seem to be wrong. Okay, claim in the DC and within jurisdiction. But DC still has the power to order transfer the entire proceedings to the CFI or the land tribunal. So when would that happen? Maybe because based on the subject matter of the proceedings, it involves very complex issues of law. So the DC may consider it is in the better interest of the parties for this issue to be decided by the CFI, or maybe it is about some specialist land issue where DC might prefer for the land tribunal to deal with it. CFI so let's say the claim is started in the CFI. CFI may order a transfer to the DC of the claim, but not the counterclaim, to DC. CFI must order, so this must order unless the CFI is of the opinion that the matter ought to remain in the CFI by reason of some kind of importance or complexity or other reason. So this is just the flip side of this order where the matter was commenced in the DC. If both the claim and the counterclaim are in the CFI, but they're outside the financial limit of the DC. Now again, this on the face of it does not seem to be wrong. But if the parties consent, the CFI may still order a transfer to a lower court to the DC. Now, it may not seem to you, why is this significant? Who cares? Okay, why would we want to have our action in the lower court? The significance is there's a different scale of costs. So in the CFI, the lawyers can charge more. Everything costs more in the CFI. So one may prefer to adopt the scale of cost in the DC. So that's why there is a need to determine should there be a transfer of proceedings. Once a order of transfer has been made, there might be certain issues about cost order, so who is to pay costs. Generally, the transferring court, so whether it's DC or CFI, has the wide powers to make cost orders in respect of proceedings prior to transfer and also the transfer. Also, the receiving court has discretion as to cost of the whole proceedings both before and after transfer. So both courts have power, but the receiving courts has a wider power to decide on costs of the entire proceedings. Okay, so whether it's before or after the transfer. If a party brings an action in the wrong court, there could be some cost consequences. So if P brings it in the wrong court, even if he wins, he may be penalized in costs. So for example, P brings an action in the CFI, but in the end, let's say the claim is more than $3 million and $3,000 again. But then the CFI decides that only awards damages less than $3 million. So it might be, in hindsight, wrong or too risky to commence action in the CFI. So the CFI may only allow costs to be recovered on a lower scale, on the district court scale. How does the court determine? Was it whether it's obvious to a reasonable, so objective test, plaintiff or his legal advisor that the case was a DC case rather than a high court case? Subjective intent is not normally relevant.